One beautiful day in Washington, D.C., a 12-year-old girl named Antje Hedgepeth was arrested by an undercover transit officer on her way home from school. She was handcuffed, taken to a juvenile processing center, fingerprinted, photographed, and detained for 3 hours. Antje was not arrested for murder or assault or theft. Rather, she had the audacity to eat a French fry on the subway. The United States Court of Appeals for the District of Columbia Circuit sanctioned her 3-hour incarceration. This case, which would have normally been brought in a District of Columbia City Court, was filed in federal court in Washington because the girl's mother claimed the Washington Transit Authority had violated her daughter's right to equal protection under the law. If children on the subway are subjected to such unconstitutional conduct, imagine what adults face when police officers have the right to lock them up and treat them as guilty before even the semblance of a trial is held. And then imagine a court system that denies the presumption of innocence until the jury is impaneled. Probably the least questioned and most believed government lie is also the most famous maxim of the American judicial system, that all persons are presumed innocent until proven guilty beyond a reasonable doubt. This presumption of innocence is a standard taught to the youngest of school children, and which the government hails as a founding principle of justice, because it presumes that, like the oft-repeated Lord Justice William Blackburn ratio, better that 10 guilty persons escape than 1 innocent suffer. Of course, innocent until proven guilty has been at the core of Western judicial systems since biblical times. We are indoctrinated so thoroughly that the average person rarely considers whether the phrase is true or not. Yet when we carefully examine the system, we find that it does not function as the government would like us to believe. Beneath the surface of various platitudes, the falsity of the presumption of innocence becomes readily apparent. The presumption was first recognized by the United States Supreme Court in Coffin versus the United States, 1895, in which it stated that the principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law system. Somehow, though, this undoubted law of presumed innocence has been tossed to the wayside by the courts, though the government continues to teach it in its classrooms. In 1951, in the case of Stack versus Boyle, the Supreme Court held that the traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. Unless this right to bail before trial is preserved, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. Yet less than 20 years later, President Nixon signed a bill into law that allowed judges to consider the factor of danger to the community in non-capital bail cases, with the Department of Justice arguing that the presumption of innocence was merely a rule of evidence, with no application to pretrial proceedings. Apparently, even though one is innocent until proven guilty, what the government hides is that this principle applies only during the trial, and that the government believes that defendants are guilty until trial, if convenient for the government, under the auspices of community safety. Astoundingly, what the Supreme Court had just reaffirmed in Stack versus Boyle as a traditional freedom that secured the presumption of innocence was now being legislatively eroded on the claim that such grand principles do not apply between an arrest and the beginning of a trial, a period of time that is almost always much longer than the trial itself. Even if we were to accept that people the government deems dangerous should be kept separate from the community, they do not deserve to be treated like convicted criminals. Yet even though the government has often claimed that they are not, this is not the reality. Once in jail, there is no distinction made between the innocent and the guilty. Instead, the indicted but not convicted prisoners are mixed in with those convicted in overcrowded jails, regularly subjected to degradations and restrictions amounting to punishment. Imagine that, punishment beginning before you have had a chance to prove your innocence, even though the government should actually be proving your guilt. Is that consistent with the presumption of innocence? The United States Court of Appeals for the Second Circuit in Wolfish v. Levi, 1978, certainly did not think so. It held in this class action suit brought by all persons detained in New York's Metropolitan Correctional Center that the restrictions imposed on innocent defendants were unjustified and violated their right to be treated as innocent until proven guilty. Unfortunately, the Supreme Court of the United States chose to approve the actions of the government while attempting to maintain the myth that one is innocent until proven guilty. On appeal, then-Justice Rehnquist wrote that the presumption of innocence did not have any application before trial. The result of this, noted by Justice Thurgood Marshall, was effectively the same as if the court had chosen to decree that the presumption did not exist at all. These cases, which assume that once you are arrested, you will be considered guilty until your trial starts, began the resulting erosion of the presumption of innocence. And while school children are still taught that this maxim is true, at least in government-owned schools, the government continues its lie, claiming that it has not abridged this right, and justifying itself with the constant "for the public safety" argument. These supposedly innocent people cannot be judged as such because they may present a danger to society, and whether or not the argument has justification, its outcome still results in people like Anchi Hedgepeth, who should be considered innocent under our system, being adjudged as guilty and punished before they have had the chance to defend themselves. In essence, these people are considered guilty until they have a chance to prove their innocence at trial. If our courts can lose sight of such a presumption of innocence and continue to authorize the police to arrest you at any time for even the most minute crimes, like not wearing a seatbelt while parked or juggling cigar boxes on a sidewalk in Times Square in New York City without a license, then our rights extend only as far as the police subjectively allow.